And I think we took that idea seriously in the Brown era, in the decision that followed. But I think we've gone back to a period in this country where we believe that as between liberty and as inequality, that the higher principle is liberty. And that if ever the court has to choose between enforcing liberty and promoting equality, what the court will tend to err on the side is on the side of liberty. And what this means is that any group, for example, who believe that perhaps they are not quite fully participating in the life of the country in terms of civil rights, the court will say, well, to the extent that your liberty is guaranteed as well as anybody else, then it is not really the job of the government as a constitutional matter to truly push for equality. And with that philosophical idea, I think that's why I call it the post-modern Plessy era. Because what it means is that we've reached a point, particularly with the 5-4 split of the court, that it is probably unrealistic to truly expect rigorous enforcement of civil rights. Thank you.
Good morning again. My name is Lexer Quamie, and I wanted to thank you very much, Dr. Harris and Mr. Stewart, for having me here this morning. It's really an honor to join you and to engage in a discourse with you, and hopefully we can answer some of your questions and maybe have a sort of candid conversation. As Mr. Stewart mentioned, I am counsel with the Leadership Conference on Civil and Human Rights. Admittedly, I'm probably one of the most junior sort of policy counsel at the Leadership Conference. And what we are is a coalition of over 200 civil and human rights organizations, primarily, or rather exclusively, national organizations, civil rights groups that sort of span the realm, whether it be specifically women's rights, religious discrimination, groups like the NAACP, the American Civil Liberties Union, several unions are members of our coalition. And in part, our strength, I think, really was born out of our founding and realizing that to really effectively engage our government, our Congress, also the courts potentially, and sort of effect change, we actually have to work not just as one group, but really find strength in the breadth of our sort of diverse backgrounds, our strength. And so there are lots of pieces of legislation that we work on currently that seemingly might just affect women's groups or African American people. But in fact, and many of you that have already studied or started studying the civil rights movement, you'll find that some of our major successes, passage of the Voting Rights Act, for example, it really happened because of the coalition of several groups. So that, I think, was sort of the strength over the last few decades of the Leadership Conference, and it currently is to this day. I'll sort of share with you what brought me to the organization, and then sort of speak about maybe 2 or 3 pieces of legislation that we're currently working on, or that I'm working on, that I think illustrate some of the breadth of our work and why it has really been a fascinating place for me to work. As Mr. Stewart mentioned, my background is in employment litigation. I worked at a firm for several years. And in many ways, there you're supposed to be sort of a zealous advocate for your client and work within the current structure of the laws as written to win. Whether or not regardless of how you may personally feel about a particular issue, really your task is to interpret the law and sort of try to convince the judge that your client is right. I found that to be at times rewarding, but then at times realizing that the way the laws are currently written, perhaps there are some loopholes, or there may be some changes that would even sort of improve or make me an even better advocate for my client. As was often the case, I found that there should have been some changes in the law that perhaps would have made the outcome a little bit different. So sometimes I thought that maybe I was on the wrong side, to be quite candid. But what I found was that I felt that it was a little bit more effective to be on the side of drafting the legislation, weighing in at the front end, or in some cases, if there's been a Supreme Court decision that the advocates think will have a sort of disastrous effect or a deterrent effect on many of our clients and the work that we do to try to help to introduce legislation that would perhaps overturn that decision. So you hear very often about legislation that may have overturned a case. So to give you one example, there is a piece of legislation that the Leadership Conference worked on. It's called the Lilly Ledbetter Fair Pay Act, and it was a direct and immediate response to a Supreme Court decision. It's called Ledbetter versus Goodyear. And for those of you that may remember, actually the Ledbetter Fair Pay Act was the very first piece of legislation that President Obama signed when he began his current term. Advocates across the board were really sort of alarmed by this particular case because essentially what it did was it said to women in particular that the amount of time that they had to bring a case against their employer for discrimination based on unfair wages was really limited to just the sort of window just before they received their last paycheck, just before the decision was made for them to receive that particular wage compared to their male counterpart. It made the window very narrow. What the Lilly Ledbetter Fair Pay Act essentially did was said, you know what, no, it's not going to be as narrow a window. We can go back even further to when that decision was initially made. So it actually strengthened the ability for what's called plaintiffs or individuals to bring a case. And so this was a coalition of religious groups, believe it or not, women's groups, labor unions that were on board. And similarly, we see that same sort of coalition coming together now for another piece of legislation that's currently pending. It's the Paycheck Fairness Act. I won't go into the details, but I'm part of a sort of large coalition of groups, the same types that I've already rattled off, that are looking at ways to even strengthen legislation that was passed years ago, the Equal Pay Act of 1963, and saying, you know what, that was a good start. It helped to level off wages in between men and women, but guess what, we have to go further. I mean, right now, women make 77 cents, actually 78 cents to the dollar for their male counterparts. Some of the guys might think that's fine. Some of you think that's a problem. Many folks, regardless of their gender, think that is a problem. And so there are ways to strengthen this Equal Pay Act of 1963, make it a little bit stronger, allow women to receive the same sorts of damages that one could receive under some of the Civil Rights Act. So as an African American employee, if you sue your employer and the court finds, you know what, you were successful in your suit, you were right in your claim, you received certain damages. Currently, women don't have that same sort of redress should they find that they were being paid unfairly compared to their male counterparts. So those are some of the loopholes that we're hoping to close in the Paycheck Fairness Act. What makes it even more exciting and at times challenging is the current political climate. Some of you may know that midterm elections are coming up in a few weeks. Congress is about to go on recess. The economy is what it is. People don't have jobs. It's a very stressful time for many, but yet there's still a pressing need, we believe, this group of advocates, to pass this legislation. So we're constantly calling our senators and Congress members, writing, visiting them, meeting as a coalition to think, what's the best way to get this legislation passed? Is it attaching it to a larger bill? Is it introducing it by itself? It sounds like this is a narrow issue to many, but it's going to have broader effects should this piece of legislation pass. There are other bills that I'm currently working on that had been introduced well over a decade. My colleague mentioned racial profiling suits. The Leadership Conference does not litigate at all. We are advocates, lobbyists on civil rights issues. Again, it's attractive to me because while it's so important for us to continue to litigate, at some point we also, I believe, have to strengthen the laws so that when we are litigating, we can say, you know what, there's no question, my client has been, or this individual has been subjected to, or these individuals who live in this neighborhood are subjected to a greater portion of illegal searches and seizures compared to these African Americans compared to non-African American individuals. And so the law says, guess what, New York City or Washington Metro Transit Authority, subject to receiving certain funds, you actually have to strengthen your data collection provisions. You actually have to provide more sensitive training about racial profiling. And guess what? Individuals have the right to sue should they feel that they are subjected to racial profiling. So working on legislation that's called the End Racial Profiling Act. It was first introduced well over a decade ago. And as many of you know, I mean, so many things have happened in the last 10 years between terror attacks and threatened terror attacks and wars, and in many ways, racial profiling has broadened for many of it. Truly has broadened, because I think years ago we thought of it as driving while black or brown. Now we have to think about, now that racial profiling may be encompassed by border security concerns or flying while Muslim. I mean, certainly there, many groups are profiled in many ways in different sort of types of vehicles. And so this particular legislation, advocates sat down 10 years ago and said, okay, we've got to, change this problem of driving while black or brown. How do we do this? Now we have to broaden this piece of legislation to encompass racial profiling in all its forms. So it's seen many obstacles and hurdles, but we are hoping that, if not this term, maybe next term, maybe at a time where it's politically feasible to get this legislation voted on and actually enacted, so that it'll actually trickle down to state and local enforcement agencies. I won't bore you with examples of other pieces of legislation they're working on, but I must say it's extremely exciting for me to think about ways that we can improve the current body of laws that we have. I mean, we have our Constitution, we have the ensuing amendments, and we have a slew of civil rights bills and statutes that have been passed since then that get us a little bit closer. But I still think that we have a long way to go. I mean, with every passing day, there are sort of new ways that, quite honestly, our rights may be infringed. And so what we have to do is actually sort of catch up and make sure that the legislation can meet those. Can sort of catch up to where our laws are and create a sort of body of legislation, so that individuals, should they feel like their rights are being infringed, actually have some recourse. The last thing I'll say about the Leadership Conference is, we do lobby, but we also organize other groups. And I mentioned the economy, and I mentioned the sort of joblessness rate, as many of you are well aware. But coming up in just a few days, we're going to be taking part in a One Nation Working Together rally, march. It's called 10-2-10. It's going to be on October 2nd, and we're hoping that students, unions, other civil rights groups will be able to participate in what will be a full-day rally and sort of sets of discussions about how we can turn around or how we as individuals or collectively can turn around sort of the current state of our economy, and sort of turn around the rate of joblessness that currently is pressing upon us. And it's called One Nation Working Together. You'll see in the next sort of coming months, now that you hopefully know something about the Leadership Conference, and what we do is that we find ways to bring together other organizations and people that normally might not think about sort of marrying their issues, but realize that it's really together that we can hopefully bring about change. I have other, many other thoughts about the work that I do, but I wanted just to highlight a few pieces of legislation that I work on, what excites me about it, the potential to bring about change, and would love to answer any questions that you all may have about my work or any of my thoughts.
Okay, what I'd like to do now is ask if there are any questions from students, and if not, I have a question. But do you guys have? What I'm going to do is I'm going to take this and walk around with it, so bear with me.
Hello, my name is Shaquille Turner. I'm a political science major from Denver, Colorado. I was confused a little bit. Can you give a brief overview of Section 5 of the Civil Rights Act? Because I'm unfamiliar with it.
Of course. Section 5 of the Voting Rights of 1965 is something that is so-called Preclearance Provision. And what the Act provides is that there are certain jurisdictions or states or municipalities, but let's just call them jurisdiction, where if they're going to make any changes to their voting procedures, they first have to obtain permission from the Justice Department, Civil Rights Division, before they do so. And the reason why it was put in originally in 1965 is that it focused originally on mostly southern states who were using various means and techniques such as poll taxes and literacy tests to deny African American the right to vote. In other words, on the surface, you had the right to vote, but then those towns or cities or states would use various tricks to keep you from voting. And what the act did